father. And so when he came in, I left out, and that was the last time I saw Christian.
Were you able to say goodbye or give him a kiss?
I was able to, but I just didn't, I didn't feel good about saying goodbye because I thought that was the last time I get a chance to see him.
Police considered Ferguson the prime suspect in his son's death, but did not have enough evidence to arrest him until 2019.
DeJuan Ferguson did not kill his son. When Christian got sick, DeJuan did what he normally did, which was to take Christian to the hospital. On the way to the hospital, DeJuan realized he should have called ahead. He typically called ahead when he would take Christian to the hospital, so the hospital staff could get the room ready for Christian's arrival.
All right, let's bring in the think tank. Joining us tonight in Fort Lauderdale, Florida, former prosecutor and former assistant state attorney and counsel for Ben Crump Law and trial attorney Sue Ann Robinson. In Houston, Texas, criminal defense attorney Brian Weiss. And in Cleveland, Ohio, criminal defense attorney Ian Friedman. Thank you all for being with me tonight. Truly appreciate it. So first and foremost, of course, I want to get your reactions to this verdict. I can tell you, I wasn't necessarily surprised. I was surprised at how quickly it came back. I thought there was some issues with the state's case, but in the end, wasn't surprised at all. Let me begin with you, Sue Ann.
On this verdict, when a young special needs child falls through the cracks and ends up missing like this, everyone is just looking for someone to be accountable. And I definitely feel like in this case, with it being cold for almost 19 years, that DeJuan Ferguson definitely fell into that category. You're absolutely right. There were a lot of problems with the state's case, including that the state was cold, that he had been cleared 19 years ago. And it's hard as a defense attorney to defend a carjacking that happened 19 years ago. It's not like today where there's CCTV and people have cell phones, and he was stopping to make the call to the hospital on a payphone. So that just gives you a context of how long ago it was and how there weren't as many advances technologically if what he said occurred, for him to kind of preserve that evidence 19 years later to defend himself against these accusations. So I definitely wasn't surprised because it's such a heinous crime. And the state definitely did a tremendous job of giving the jury a lot of evidence to show that he wasn't doing his best as a father in terms of his son's medical condition, which obviously, based on the jury's verdict, proved to them that bad father could have killed his son.
Yeah, and actually that's an important point because we actually got a chance to speak to a juror, and we'll play some of that in a little bit. But the big thing for them was that, you know, all the evidence that came in about the neglect, that's where they saw the deliberate acts that led to the first-degree murder. Brian Weiss, let me get you to ring in.
Not surprised at all, Michael. Look, major props to prosecutor John Schlesinger for overcoming the hat trick, the triple crown, if you will, of potential prosecutorial landmines. Number one, this case just wasn't merely cold. It was cold of Arctic-like proportions. Number two, no body. Number three, overcoming our belief system that no parent could ever be motivated to kill his or her own son or daughter. And when you look at it through that backdrop, the fact that this jury heard 5+ days of testimony and came back in 2.5 hours leads me to believe they had no doubt at all. I've seen juries out longer and no test DWIs over a holiday weekend, guys.
You know, it's interesting, again, speaking to that juror, there were 11 people who right off the bat voted for conviction of first-degree murder. The one we spoke to was the only holdout. Didn't take her long to sort of flip over. Ian Friedman, you know, there was a lot of evidence that came in about this guy, about his lifestyle, about the type of person he was, the things he did to this kid. That, to me, was the biggest hurdle for this defense.
Yeah, Michael, you know, in these types of cases, in the courtroom, inevitably, every time a judge says, ladies and gentlemen, you're here for the case of, and here's the charges. If it's this type of case with a child, just as Sue Ann said and Brian's alluding to, always we see a juror look over right away at the defendant and they're asking themselves, can I see this person doing that? And here, there was so much evidence of the neglect and, you know, the lack of nutrition and the partying, and they even got into sex and so forth in this case. And all of a sudden it becomes, well, yeah, I guess this could be that sort of person. So of course the prosecutor spent a lot of time on that. And because he knew, right, this was a circumstantial case, and this was the perfect example of, what juries hear all the time. You can, you can consider circumstantial evidence. You can give it the same weight as direct evidence. And here there was a lot of circumstantial evidence. And I agree with Soham, when you have a child that is believed to be dead or is dead, the jury wants accountability. It's the natural inclination to protect the child. So I'm not surprised either. 3 hours, agree with Brian, says it all. They absolutely believed it. And, this is the judge is now giving them the defense time to give motions, to have the judge overturn it. I don't see any necessary basis for it, so I anticipate at sentencing, judge is going to do only what he can do, which is life without parole.
I see a couple of issues, but we'll touch on that in a minute, because right now, what I want to do is, Theda Person was the mother of Christian. Lynn Ferguson was the sister of Christian. Both provided pivotal testimony for the state. And of course, they wanted justice for that little guy, Christian. Here's how they responded to the verdict.
It means so much to me, even though justice has been delayed, it has not been denied. So I'm just glad to be here, and I look forward to, just getting used to this feeling and learning how to live in spite of these circumstances.
Sure. And Lynn, what was it like to be in the courtroom and hear guilty of first-degree murder?
Honestly, it took me a minute to really process it. I think the same with you.
Yes.
Yeah, I mean, but I did at one point, kind of overwhelmed, but definitely looking forward to it. It's a long time coming.
Right. And what does this mean to you now, this verdict of guilt?
It means that my mother, who's been called a liar all her life, me even, called a liar, told this is not, what happened to you by, family members on my dad's side, this is not what, we want you to say. This is your father, don't say anything bad about your father. And there are a lot of things that were not heard in testimony that, will come to light in the future as well.
Sue Ann, in the interview with the jurors, she basically, these were her exact words: DeJuan Ferguson was a monster. If you have a juror saying that, you got no shot. But at the end of the day, again, you can hear the relief in the family's voice. Lynn Ferguson's testimony, I think, was pivotal as well. She was the one that sort of put DeJuan Ferguson in the room with Christian. She was in the room. She says he took him out. And that was, of course, the beginning of that night where he was never seen again. Your thoughts ultimately on justice for Christian here?
I think it's important that someone has been held accountable. My issue with the case throughout, aside from it being circumstantial and super cold, has always been during the testimony, there were so many other people in the chain, people who were mandatory reporters that just allowed Christian to fall through the cracks, when obviously based on the testimony, based upon the father's lifestyle, based upon him tying Christian down, needed to be reporting and stepping in and stopping this from happening. So I'm hoping that now that the mom has this verdict, that the family is going, has the opportunity to advocate for kids in this circumstance. Because if they don't, then his life was wasted. I think there's so much more that can be learned from this moment than just DeJuan Ferguson going to jail. It's to say, listen, when people are calling Child Protective Services so many times that the judge had to ban the mother from doing it, maybe there needs to be a chain of command, accountability within the social worker system, something to stop special needs kids like Christian and all kids who are involved in the system from falling through the cracks at abuse like this.
Yeah, Evan Harris was the juror that Chanley Painter, our reporter out there on the ground, spoke to. I want to listen to some of what she had to say about exactly what you're talking about, Sue Ann. How many people failed this kid? Let's listen.
Now that I've heard the whole case, the best time was their best defense, that some of the eyewitnesses and that there was a lot of people in Christian's life who were mandated reporters and did not report
That's a great point, yeah.
the neglect that was happening. That's about their best evidence that it has been a long time, and DeJuan Ferguson has gotten away with this for such a long time.
Yeah, there can be no question that this kid was failed by lots and lots of the adults around him who was supposed to take care of him. But Ian, I want to touch on something we talked about a little bit earlier, and that's the idea of appealable issues. DeJuan Ferguson wanted to testify. Once the case was closed and the rebuttal case was over, evidence was in, prior to closing arguments, he came back in and said he wanted to testify. The judge denied him that ability to testify. I wonder if you think that is a solid appealable issue.
It's obviously going to be appealed, so it's a solid issue for appeal. What the court does with that, we shall see. The court would have gone through, an exchange with him about, his right and right not to testify and so forth. His lawyers would have. It's certainly something that's going to be appealed, as are many issues in a case like this. As I had alluded to a moment ago, where it's going to be raised is with the trial judge. A lot of these issues, I don't see it. The judge making any changes there. So the defendant, after he is sentenced, certainly will take that up to the court. That'll be one of many issues.
The other issue, Brian, that I want to touch on is this idea they let in so much evidence. There was evidence, or not evidence, but there was testimony. Lynn Ferguson testified that he abused her. There were some arguments early on before the trial about letting that type of testimony in. They heard a lot about his polyamorous lifestyle, things of that nature. Do you think that there were some issues letting all of that in? We just saw Justin Ross Harris's case here in Georgia overturned because too much of that negative information was brought in about things that didn't have to do with the actual acts that he was charged with. Do you see a problem there?
Look, I tell trial judges and prosecutors when I have the privilege of lecturing at CLE seminars on extraneous offenses, what Jack McCoy on Law and Order calls prior bad acts. Extraneous offense evidence is for the needy, not the greedy. And there is no quicker way to get a conviction tossed on appeal than trying somebody as a criminal generally, whether or not there were limiting instructions, whether or not the state had a need for the evidence, whether or not the defense opened up any doors, are all going to play into the appellate template of what happens further down the road. But I just want to make 2 quick points because it's tough being a closer behind these 2 great guests. Number one, this case underscores, in no uncertain terms, why the penitentiaries are filled with convicts convicted on circumstantial evidence. And number 2, I've learned more in 4+ decades as a criminal defense attorney and special prosecutor from The Godfather than I have from Southwest 3rd. Remember, in that penultimate act, Michael tells Carlo, you got to answer for Santino. Today, DeJuan Ferguson had to answer for young Christian.
Yes, he did. Now, Sue Ann Robinson, you also heard in that sound from the juror that she thought time was the best thing going for the defense. And the fact that the kids were so young when this happened, and now we're asking them to testify 18 years later about something that happened back then. There were lots of changing stories. At the end of the day, do you think the defense did a good enough job playing with that particular card in this case?
The defense did all they could with that particular card, but the state had an entirely circumstantial case, as we've discussed, based on his character evidence. So it's hard to say to the jury, hey, he's a really bad guy, but this happened a long time ago, so it's possibly not true. They did what they could with the card that they had, but I don't think there was more you could do with saying, hey, it was a cold case, other than to really bring home the point that he obviously had been cleared at one point. And then, based on the state's case, then a new investigation, he was brought in. I think that would have helped. But again, all the bad character evidence, prior bad acts, all that stuff together just painted him as such a villain, a monster, that it was very hard to overcome.
Yeah, Ian Friedman, the other thing that surprised me, what the jurors said was, they didn't get that he actually killed them with his hands or anything like that. They thought, and here was her problem with the case, the one holdout juror, the one that we heard. She said that she wasn't sure what acts he did to actually kill the child, and she was convinced by the other jurors that his deliberate acts were the omissions of not giving him his medication, by not taking him to his appointments, by neglecting him the way he did, that those were the deliberate acts that led to that first-degree murder. What do you make of that?
That also, Michael, to go back to your last question, as to issues on appeal, that certainly will be another one. Whether or not this was sufficient, whether or not this was against the manifest weight of the evidence, all of these things are going to come because the appellate lawyers are going to argue that that does not constitute the premeditation necessary for first-degree murder. So that certainly is going to be argued. But, look, the jury didn't need the body. The jury was confident in under 3 hours to say, we don't need the body. And yes, the child is dead. And they really didn't care to find out what and I'll just say in general, weapon was, whether it was a gun, a knife, a pipe, or the neglect. It all goes back to this is a tough case with all of the circumstantial evidence and all of the people giving kind of the little bits and pieces over the years. It was tough because, again, the inclination begins with wanting to protect the child and bring accountability. It really is a tough hurdle from the defense perspective. And in this case, time certainly could have helped, but it also, there wasn't a lot to do with the time element. I mean, you could say, yeah, in time, memories faded, there were different stories, as Sue Ann said, there was a clearance there, those sorts of things. But I think if you look at it almost on a scale balancing against each other, it was pretty clear that if the jury wanted to find someone, there certainly was that justification. The scale was certainly lower on the circumstantial presentation for the state.
Absolutely. Now, I mentioned earlier that sentencing was delayed, but it's only delayed just in terms of time. There's only one sentence he can get, and that's life in prison without the possibility of parole, justice for Christian Ferguson. All right, the think tank is going to stay with me, and when we come back, we got a verdict in Ferguson, but we remain in a verdict watch in the trial of a man accused of killing artist Nipsey Hussle. The jury in LA has gone home for the weekend. More after that. More on that when we come back from the break. Keep it here on Closing Argument.
3082.
The streets he used to run as a young man became the life material that he used to become a voice for those same streets. And while some people get successful, they make money, they leave their neighborhoods, they change their address. This man was different. He wanted to change the neighborhood. He invested in the neighborhood. He kept the same friends from the neighborhood. And the neighborhood loved him. And they called him Neighborhood Nip.
That was prosecutor John McKinney delivering his closing argument to the jury yesterday in the trial of the man accused in the shooting death of hip-hop icon Nipsey Hussle. Now, Hussle, once a member of the LA gang, the Rolling 60s, had turned his life around, becoming a Grammy-winning recording artist and entrepreneur. The jury heard 9 days of testimony from over 20 witnesses. Well, now all of the evidence is in, and the jury has begun deliberating. But this case isn't a whodunit. Holder was caught on video pulling the trigger and killing Nipsey Hussle. The question for the jury is whether or not the shooting was premeditated or was Holder acting in the heat of passion after Hussle told him word on the street was Holder was a snitch. Well, let's listen now to some of the closing arguments from both the prosecution and the defense.
He started thinking about this well ahead of actually pulling the trigger. He could have stopped at any time. When she said, "What are you doing with that gun?" he could have changed his mind. He didn't. When she parked behind the Fat Burger, he could have said, "You know what, let's go." He didn't. As he's walking down the alley, calmly, with his French fries, he could have changed his mind and went back, but he didn't. When he turned the corner and he saw that Nipsey Hussle was sitting there with other people he didn't know, and he knew he was about to shoot, he could have changed his mind, but he didn't. That's what it means to premeditate and deliberate on an act. After each shot, he could have stopped, but he did the next one and the next one. That's premeditation and deliberation.
So while under
that heat of passion, from that provocation, from Nipsey Hussle, this serious accusation done in this manner, a mere 9 minutes later, he shot and killed Nipsey Hussle. 9 minutes is a very short period of time for such a serious, life-threatening provocation and accusation like this. 9 minutes. Clearly, emotions did not have time to clear in that short amount of time. As soon as Mr. Holder got into the car, he told Brianita, drive around the block, which he did. He took out his gun. She parked in the alley after he told him to. He gets out of the car and he walks over and he shoots Nipsey Hussle. There was no cooling off period. There was no time to reflect. He was still acting under the heat of passion of that provocation. Look when he first approaches the group. He doesn't have any animosity in his heart. He's just coming over to say hello. It was because Nipsey Hussle made this accusation against him. That's what provoked him. Otherwise, he would have gotten his chili cheese fries and he would have went back along his way. This was the act that provoked him. This was a provocation and there was no cooling off period. The burden then is on the district attorney to show beyond a reasonable doubt that there was a cooling off period. So let's look at the timeline of events. And this is from Defense Exhibit I, and we'll play that for you in a minute. At the 10-second mark, Eric Holder joins the group, shakes their hand, leans up against the car, and Nipsey Hussle starts talking to him about having paperwork on him. At 44 seconds, Brianita Nicholson joins the group. And she stays for about 53 seconds. At 4:20, Eric Holder leaves the group. At 7 minutes and 10 seconds, Eric Holder comes back and says goodbye. And at 13 minutes and 30 seconds, Mr. Holder returns and starts shooting. It's only 9 minutes and 10 seconds from the time Mr. Holder left the group after being accused of snitching to the time of shooting. Is that a cooling off period for such a serious public accusation by someone of the status of Nipsey Hussle? That's a very short amount of time to expect someone to cool off for this range of emotions.
All right, let's bring back in the think tank. Still with us, trial attorney Sue Ann Robinson, criminal defense attorney Brian Weiss, and criminal defense attorney Ian Friedman. And Brian, I'll start with you, because I thought it was really a decent job by this defense in painting Nipsey Hussle as this sort of shadowy figure. We all know him as the icon, as a guy who really turned his life around. But there was a lot of testimony that there may have been some still involvement with these gangs. And, you know, it begs the question, why was he involved on street-level stuff like this, telling a guy that perhaps he might be a snitch, or there was paperwork that he had talked? All those things kind of, I think, something that the jury could be struggling with. They started this morning. They deliberated all day, something I didn't expect, especially on the day before a long weekend. Your thoughts on this case so far?
Michael, I think it's clear that every murder is a tragedy on multiple levels. What makes this case so much more so is that Nipsey Hussle was gunned down in the neighborhood where he grew up, that he loved and cared for, and was loved and cared for in return by someone whom he considered a friend. Why? Because in Crenshaw and so many other neighborhoods across this nation, being accused of being a snitch is a capital offense. That, to me, is a tragedy of its own making. And it's interesting, the defense did what it could to set a template for the notion that the defendant, who, by the way, shares the name with the former attorney general, which kind of freaked me out early on,
That's right.
that he didn't have time for cool reflection. And it's ironic, guys, because I think the first time I ever heard the legal definition of murder was on Dragnet. I'm a lot older than you guys, and I grew up watching the legendary Jack Webb. And in trials conducted in this very courthouse where we just saw that great video, we learned that 187 PC in California was the unlawful taking of a human life with malice aforethought. You don't need to plan this out again over a long holiday weekend. You can form intent in an instant. And as far as I'm concerned, the notion that 9 minutes is an awfully short time frame in which to lose that sense of cool reflection. I've seen cases where 9 minutes, guys, can be considered a legal eternity.
Absolutely. Sue Ann Robinson, you know, there was testimony that he actually got in the car, he loaded his guns, he asked to be dropped off in an alley. I think he even picked up some food. He did a number of things where I guess maybe he was reflecting on this and then made this decision. But at the end of the day, he made the decision. Do you think the jury's struggling with that 9 minutes or perhaps something else?
I need more information about this jury because I've been to Crenshaw, I've been to that neighborhood, I've seen how he's lauded as essentially like a martyr of the neighborhood. So I'm curious to see who's in the jury box. The issue to me is what the defense is trying to do is, as my co-guest explained, make it seem as if being called a snitch is not just being called a name, but it's something that's so horrible that it would send you into this emotional tailspin where you would black out and have a reason to murder someone who's your friend. That's tough. And I don't know if the jury being from that neighborhood is gonna understand that mindset or if they're gonna completely reject it. I think they're definitely, the defense gave them a lot to think about in terms of Nipsey's involvement. I think that the reason why, and I think the state did a good job in explaining, listen, he's involved in these types of things and he's having these types of conversations because he's an OG now. He is out of the game, he's Grammy nominated, he's working on improving the neighborhood, and he's doing it from the ground up. He's not outside the neighborhood sending people there or sending money to the neighborhood. He's there every single day and involved in order to keep the peace in his neighborhood. And I think that it's gonna be, it's a lot for the jury to digest. And I think that the defense is doing what the defense has to do, which is try to put the jury in the defendant's shoes in making the decision to murder Nipsey Hussle. I just think it's going to be super tough with the jurors that are obviously from that area, convincing them that Nipsey Hussle deserved to be murdered for essentially probably trying to save Eric Holder's life by saying, hey, this is what the word on the street is. You might want to get it sorted out.
Yeah, there was a misunderstanding. One of the witnesses who actually heard the conversation said exactly that, Sue Ann, that what he was actually doing, what Nipsey was doing was giving him a heads up, saying, hey, you need to deal with this, take care of this, not threatening him, but maybe he felt he was hating on him. At least that was some of the exchange between the two of them. All right, think tank, stand by. We do have to take a short break right now, but when we come back, we'll be taking you on the docket with a look at the next big trial here on Court TV. Sean Pickett is accused of killing his mother and his dog. First, he claimed evil voices told him to do it, but now he's claiming self-defense. We're going to tell you everything you need to know when we come back.
Live bountifully.
On the docket tonight, we're getting you ready for the next big trial here on Court TV. Sean Pickett is accused of killing his mother and his own dog, and he claims evil voices in his head told him to do it. Court TV legal correspondent Joy Lim-Nakron has more details on the upcoming Possessed by Evil murder trial.
I was hearing evil voices. I was hearing evil voices. This is a statement made by Sean Pickett after reporting to authorities the death of his mother and pit bull named Chico. Their bodies were found in their residence in Avoca, Wisconsin. It was Pickett who called them there in early May of 2021, the day after Mother's Day. When authorities arrived, Pickett's mother, Susan, was observed having bruising all over her head and face, while Chico had multiple wounds to the chest. Pickett, on the other hand, had dried blood on the front of his pants, tops of his tennis shoes, and front of his shirt. When questioned, Pickett initially pointed blame at his mother's boyfriend, saying this boyfriend held him hostage and left him to take the blame. Moments later, he walked this back.
Count 1 alleges first-degree intentional homicide in that it alleges that Mr. Pickett did cause the death of Susan D. Pickett with intent to kill that person, a Class A felony.
He said what really happened was he, quote, blacked out, thought he was, quote, possessed, and was, quote, hearing evil voices in his head. Quote, the evil in my head said I had to kill my mom and Chico in order to go to peace, in order to find rest. There was people inside my head saying that once I kill them, that I will go to rest. He admitted he believed he had killed his mother and dog with a, quote, metal bar and knife. My mom first, then Chico. I stabbed her and beat her with that metal bar. Pickett is charged with first-degree intentional homicide for the death of his mother and the mistreatment of animals for the cruel treatment of Chico, which resulted in his death. If convicted, he faces a maximum sentence of imprisonment for life.
All right, still with me to discuss, Sue Ann Robinson, Brian Weiss, and Ian Friedman. And Ian, I'll start with you. That was then. This is now. And what it seems now from reading all the paperwork involved with sort of reading into tea leaves, we don't know for sure, but there are no mental health experts listed on their witness list. They asked for a self-defense. The defense did a self-defense instruction. The prosecution has now asked them to explain that. So we think they might be going in that direction. What do you think about a case like this where you're switching over from a mental health claim or insanity, temporary insanity claim, over to a self-defense claim where you allegedly killed your mom?
Yeah. So just so that the Court TV viewers understand, if we as defense counsel are presented with a client like this who makes those claims in a case that is any sort of case, but particularly this sort of case that's so horrendous that people automatically are going to say, what's wrong with that person? We're going to send them for a mental health referral. We're usually going to do an NGRI, not guilty by reason of insanity, which says they couldn't appreciate the wrongfulness of their conduct at the time of the offense. And then they're going to go, we're going to get professionals to go and talk to them. They may go to the court clinic, talk to the court doctors. What this tells me, Michael, is they could not find a doctor who was going to support the NGRI theory. And I want to point out there was a very small little nuance in something that was said. And I do a lot of NGRI work that it kind of would bother me. And I wonder if this was something that the doctors had a problem with. It's very difficult to say, you know, obviously he said it was the boyfriend, fine. But then he said, I blacked out, yet I heard all these voices and I was possessed. And that's very inconsistent because when we have clients who blacked out, they don't remember anything. They come to and see what happened. But to say that I blacked out, yet I have the recollection of all the dialogue within my head is problematic. So was he making a bogus claim? Perhaps, and that's probably why they have to switch to something else. They know that they can't get an NGRI, so now they're going to self-defense. I think it's going to be a really tough way to go. The jury is going to be presented with absolutely heinous evidence in this case because it was a site of a bludgeoning. And this is a terrible case. This is the stuff that, you know, the prosecutors and the defense lawyers and everyone in the courtroom, they remember these throughout their career. This is tough stuff.
Yeah, it is tough stuff. The other thing that's inconsistent with what he talked about was he remembered every detail of what he did. He actually told the police that he stabbed his mother X amount of times and that he hit her over the head with some kind of metal object. He did the same thing to the dog. So he remembered all that. That's not consistent with blacking out. But there's something else in the wind here, Sue Ann Robinson, and that's from 2015 to 2019, apparently there were a series of domestic incidents on his record. Now, we don't know the nature of these incidents. We also know that at a preliminary hearing, his mom was well known to police. We don't know, again, exactly what for, but she was well known to police for her interactions with police. Any chance at all here, if perhaps some of these domestic incidents involve mom hitting him and maybe hitting mom, you know, if that involves something there that could work in terms of a defense here, that mom, it was required for him to protect himself from his mom?
Pickett needs to go to the deepest, darkest part of the jail. There is not going to be any defense that can be lodged to any human jury that I can think of to be an excuse for someone to do what he did to his mother. And if there's a history, if he has a history of violence with his mother, even worse for him. And honestly, obviously murdering his mom, if that wasn't bad enough, then he stabs the dog. I think it's going to be a simple open and shut guilty for him. I think that the defense obviously has to put forth something so that they're not going up on appeal. But obviously they have a problem client. They have a client that first tells the police, oh, it's the boyfriend. Then he says, I blacked out. Then he's like, oh, you know what? I have mental health problems. He's just trying to come up with what he thinks would have worked, and nothing should work and nothing will work.
Yeah, and I think, you know, we talked about a little Christian in that case of DeJuan Ferguson. The only thing worse than that is, or actually, that's a little bit worse, but right in that same category is killing your mom and killing a dog, and he did both. He's going to have a hard time here for sure. All right, guys, stand by. Court TV's coverage of Wisconsin versus Sean Pickett begins Tuesday morning here with opening statements. All right, Think Tank, we'll be back in just a minute. We do have to take a break, but when we come back, it'll be time to hear from you, the 13th juror. Do you think justice was served in the missing son murder trial? Your reaction to the verdict when we return.
I spoke to Lynn Ferguson right before I left, and I just told her I hope she heals from this. I hope this brings her some closure. I hope this brings Theta some closure and Christian's entire family. I hope they can now put this to rest. It's been 19 years, and this has been a sad situation.
Well, today the jury in the missing son murder trial found defendant DeJuan Ferguson guilty of first-degree murder for the death of his 9-year-old disabled son, Christian. It was a trial that was 19 years in the making. So we asked you, the 13th juror, was justice served? And we begin, folks, with our 13th juror comment of the day. It comes from Christy, who says, as a parent of a special needs son, this case hit me hard. I think the jury got it right, and this so-called father deserves life behind bars. Shame on him. Brian Weiss, something else that the juror said, she said a number of the jurors had children. And I think right there, that was the end of the day. That was story over. As a father, and I'm sure you guys have children, listening to that and what was going on in that case, very difficult to overcome just the feelings. As much as you try to put it aside, it's hard to overcome the feelings of how this guy treated this little boy.
Absolutely, Michael. Look, Christy D, major props to you. You hit it out of the park with that email. And to paraphrase what we heard earlier, you not only need to put this man in the darkest part of the penitentiary. I believe that anybody who would do violence to any child, but particularly a special needs child, an angel, that there is a special level of Dante's Inferno in hell relegated to people like this. After 40 years of doing what I've done, I have become, unfortunately, somewhat jaundiced to the notion that crime will always be with us and that adults may or may not sign up for their involvement in the criminal justice system on some level, either as defendants or tragically as victims. Little kids, special needs kids, kids of any kind, of any race, creed, or color, do not. And once again, to the extent that this jury was out less time than I've seen in traffic ticket cases or no test DWIs, tells me they had no doubt at all in their heart of hearts that this man never needs to see the light of day again. Guys.
Yeah, they definitely spoke loudly. Let's get to our last comment. Here comes from Jan. She commented saying, I hope he tells where the child is buried. The family needs closure. Ian, that's a small part of the story. I don't think this guy, just from what we know of him, is going to do that, but that would be great if we could somehow find out exactly where he is. He said to someone he might be in the foundation of a building, but if they could get some closure, that would be wonderful.
Yeah, he did say that, and that came in the trial. He's not going to do it now. He's going to make his motions for a new trial. He's going to go to appeal, and he's going to go off to prison, either for life or if the appeals court does something different, he's going to always maintain his innocence. If that's the closure they need, unfortunately, they're not going to get it.
Yeah, maybe they get it from that testimony, you know, because he said that he put that kid in there. But to Brian's point, maybe that's where he needs to be, on some building and a foundation as well. But we don't do that in this country, so strike that from the record. All right, a big thank you to my think tank, Sue-Ann Robinson, Brian Weiss, and Ian Friedman. We always appreciate your expertise. Thanks for joining me tonight. Right now, it's time for a break, but don't go anywhere. When we come back, I have a photo to show you of a child who isn't home tonight and should be.
AppAthletics.com.